2 weeks had some of the most highly anticipated developments in the ongoing cases of the PDAF scandal. 2 of the 3 senators allegedly involved in the pork barrel scandal have been arrested and filed with plunder charges, and both have filed for petitions for bail. While the country waits if the courts will also arrest and file charges against the 3rd senator allegedly involved, the 1st senator to be arrested has already pleaded not guilty to the charges. Debates have started on whether or not the persons involved should have filed for bail, given the gravity of the accusations against them. Under RA 7080 or the Plunder Law, plunder is committed when a public officer, either by himself or with the participation of other people, amass ill-gotten wealth through a combination or a series of overt or criminal acts. Under the law, the penalty for proven acts of plunder is life imprisonment and disqualification from holding any position in public office. In the amended Section 2 of RA 7080, based on the death penalty law, anyone who is guilty of the crime of plunder shall be punished by reclusion perpetua to death. The questions that are now on people's minds are, will the Sandigan Bayan grant bail to the 2 senators accused of plunder? Should they still hold public office while they are awaiting trial? How long before the people see fruition in the pork barrel scandal cases? Good evening. You are watching Legal Help Desk on the Solar News channel. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Jimeno.
And I'm Attorney Nepomuceno. Tonight, in light of the development of the PDAF scandal case, we will discuss the plunder law and how to file a motion for bail, what you need to know about plunder and its penalties, as well as the process and requirements for filing for bail.
Our guest for tonight is Department of Justice Assistant Secretary Jeronimo C. Good evening, and thank you for being with us.
Good evening, Karen. Good evening to everyone.
Yeah, thank you for taking the time.
Especially now, he's been very busy.
I know. It's, thank you for taking the time because of all that's happening right now, and obviously everyone is reading it in the papers. There are a lot of things going on, and for a lot of people, it's just going like this. No, they kind of don't understand what's going on, what are the processes and all that, and obviously the technical or legal meaning of plunder vis-a-vis
Or in the first place, maybe we can explain why the PDAF scam is relevant. Meaning, because of the PDAF, what can you file against those people who are involved?
It's a timely topic because not a lot of people understand the relationship between graft and corruption cases and plunder. The way you look at it, graft and corruption cases in general is the range of criminal behavior that is that prohibits public officials and of course including the complicit private persons that are against their violation of their public duties and public trusts. So that is general graft and corruption cases. Plunder, because we've seen that graft and corruption cases are not as effective so far in our history as a country. So plunder was designed as a law especially for big graft and corruption cases that have breached 50 million pesos and above. So the policy of the legislature, which is the plunder law, Republic Act 4020, is actually to come up with heavier penalty for those that are bigger in nature in terms of amount. So you look at the subset of plunder as a part of the bigger set of graft and corruption case.
Okay, so just para clear to the public, give examples of just graft and corruption cases, for instance.
There's so many cases. One is if you're entrusted with public funds, the use of public funds, you're supposed to use it judiciously. You should not use it for private interest. For example, you would have a construction of a road or an airport or seaports. Whatever fund that is given to you should be used only for that purpose and only use optimized so that the maximum public benefit can be done. This is the concept of taxpayers' money.
And this also applies to the level of even, kunwari, yung mga clerks sa government agency offices.
Yes.
Pagka pumayag sila na mga fixers, for instance, and they're aware, tas they're working with the fixer para mapabilis. That's graft and corruption.
Pero in that case, no, you're not talking about government funds. Because if it's, let's say, bribery or let's say parang under the table, you're talking about the fund of another person.
Correct.
And,
So that's
and
another
make
form
money.
of
yeah,
graft and
so that's
corruption.
so plunder wouldn't be that, right?
Correct. In the sense that it's not the quote-unquote what we know as a fixing kind of naglagay ka ng 50 pesos, 100 pesos to expedite a transaction. That kind would not fall under plunder simply because we always hear complaints of why there is no big fish. Why do we always go against the little 2,000, 5,000, 100,000 cases? And for the really big fishes that we're seeing, which is similar to the PDAF cases now, why are we not seeing these cases out of the woodworks? And perhaps partly because of the times and the good governance platform of the administration, you would see also these things coming out. And all these cases are not happening for the first time. These things have been there since the beginning of several administrations, but it's only now that it's coming out of the woodworks and actually being translated into cases.
As I see, you spoke about big fish, and this brings back memories of one successful plunder case that led to a conviction, which was former President Estrada. So maybe we can define plunder. He was convicted for plunder, right? So I guess to educate the public, when he was convicted, ano yung elements of plunder and what type of offense did our former President Estrada commit in order to be convicted of plunder?
That's a very good question because that's already been translated, thankfully, to jurisprudence. So we are not just discussing academically. There's a leading case called Estrada versus Sandigan Bayan from the former president. And basically, plunder is not any special form of action. It's an series of illegal actions. No, it could be just one act. It could be a pattern, a system. I think that case for the viewers is very, what I would say, informative to look at what exactly plunder would constitute of, because it can be just signing off on a check. It could be receiving 10 million pesos one time. But if it's a series that totals 50 million, that already qualifies as plunder. In fact, in that leading case of Estrada versus Sandigan Bayan, which is easily searchable and
it's public record.
It's public
People
record.
can just search that on the
Correct.
net. Estrada versus Sandigan
The
Bayan.
facts are actually of recent history, recent vintage. This is something that is not of long history. It's a fairly, I would say, jurisprudentially a new case and a landmark case because it was one of the firsts and the first actually on the plunder law. So from that, I think what's important is it has to be read in relation to the RA 3019, which is the Motherhood Anti-Graft and Corruption Law, and look at that series of actions or omissions. Combinations is the word used in the law that will come up with up to that amount of 50 million pesos. Of course, that is the major difference of plunder. And as I saw earlier in the intro, this plunder is especially pernicious because the penalty is reclusion perpetua to death, which is the most extreme penalty in our revised penal code and in our criminal law statutes.
Okay, it's interesting that you brought up the penalty of reclusion perpetua to death because reclusion perpetua would mean parang lifetime imprisonment. But we have here former President Estrada who was already convicted of plunder before, but now he's actually a public official, a mayor. So
a lot of
how
people
would you
are asking
explain
that?
that? Yeah, a lot of people are asking then,
Yeah.
akala ko ba na-convict sa plunder? Or they even forget na, nga pala, now that this PDAF case is ongoing, it brings back memories. So they were thinking, wait, na-convict dati si former President Estrada. Why is he suddenly a mayor again and he's free? So maybe that's something that you can enlighten the public on.
So when we say reclusion perpetua to death, I think this is easily understandable. Reclusion perpetua is a Spanish civil code relic, but it doesn't mean anything different from a life imprisonment. Of course, there are some technical differences for lawyers, but for us lay people, when you say reclusion perpetua, you can understand it as a lifetime imprisonment. Of course, death is death, which we no longer have death penalty that has been effectively suspended. So you're looking at reclusion perpetua as a life imprisonment in the general terms. Now, if you are convicted or if you are charged of reclusion perpetua to death, for our purpose we just call it reclusion perpetua. Of course, there is no bail, and when you get convicted, you're supposed to serve a sentence of a maximum of 40 years. But remember, former President Erap was pardoned. So that pardon has the effect of erasing your criminal liability. And of course, there's always an issue of why is eligible again to run for public office. But absent a challenge or absent a judicial decree barring him from running, he actually ran and won as mayor of Manila.
So in other words, if he wasn't pardoned, he'd still be.
Of course, he would still be in jail. That is the.
Now, a lot of people are asking: is plunder purely for government officials, or can a private citizen? And as we know, we're all reading the newspapers. There's a person now being non-government being involved, being charged for plunder. Is it possible for a private citizen to be charged for plunder?
Yes, it is possible because in many cases that we see, government officials cannot do criminal cases, graft and corruption alone, especially for such large-scale transactions, without complicity or conspiracy with private individuals. Of course, it may be imaginable that cases can be filed solely against private individuals for plunder. But in effect, the chances are there will always be a public official involved and with complicit or private individuals who would be in conspiracy or would share in the grand scheme or grand plan with the public officials. So the answer is yes, they can be charged together with the public officials because the crime is plunder, even if the objective of plunder is directed against public officials.
But is it a condition, though? Is it a condition for a public official to be involved, or can a private person be charged on his or her own
by himself without any other
government? Yeah,
very good. Theoretically, that can happen, but in practice, it's difficult to conceive of a case where a private person would be able to steal or in any way prejudice the government on his own without complicity from public
because
officials.
Of all the approvals, no?
Approvals or the sources of funds or the nature of transaction. So you would see a gap between what would be in theory possible and what is happening out there in the world.
So we still have a lot of questions, especially since may mga arrest na nangyari recently. Legal Help Desk will return after these messages. You're still watching Legal Help Desk on the Solar News channel with our guest, Assistant Secretary Jeronimo C. of the Department of Justice.
Yeah, okay, so we're talking about plunder. And I just wanted to ask Asek, no, yung elements of plunder, what are the most, number one, when you go through the plunder law, there are four things there: malversation, misappropriation, conversion, and misuse, di ba? I know that for some people, what are those, di ba? Maybe you can just run down just quick examples of when a person malverses a fund or misuses a fund.
Okay, that's a very good question, Rod, but I'd like to start with a basic idea, a basic frame, which I think would be better for listeners. No? All these forms that you mentioned, misappropriation, conversion, misuse, is actually a form of stealing, yung pagnanakaw. No? Of course, in what we call in the eyes of the law, you have to always take cases. No? For example, this thing money was entrusted to me. I don't own it. I'm not supposed to do anything with it. I'm supposed to keep it until the return of the master. So in that case, I'm not the owner. And if I use that, that's also a kind of theft already because I don't own it. In some cases, the money can be left with you for you to use for a certain purpose, for purpose A. You're supposed to buy books, but then you decide to buy shoes. No, so that's a conversion.
Or conversion.
So basically, because all these terms, if we decide to break it down into each part, goes back to the basic idea of stealing, or in a broader socio-physical sense, it's a kind of misbehavior because what is supposed to be A, you're not doing A, but you're doing B, and especially true if it's funds, property, or even the basic duty of.
That was the reason I was asking you. Misuse. When you say misuse, does it necessarily mean that you benefited from it? Because when you misuse it, from purpose A, you made it used it for purpose B, but you did not necessarily benefit from it. Is it necessary that you benefited from it?
There are two ways of looking at it because when you don't, for example, in terms of stealing, I don't mean in the concept of just magnanakaw na A and B. No? If you don't give it the best to the government, it becomes the term that we hear is prejudicial, grossly advantageous. No, even if you don't benefit from it personally, the fact that government is prejudiced is already steals from the concept of doing your
Can
best
gross
job.
negligence be part of plunder? Kunwari, you know, if some people raise as a defense na forged naman yung pirma ko dyan, but then the fact that there are several transactions na pirma mo yung lumalabas, even if it's forged, I think, di ba, others would say you should have known or dapat chinek mo at some point kung tama ba or nag-exist ba talaga supposedly yung NGO na nagdi-deal with you for you to find out. So is that possible that someone who claims na wala siyang alam or hindi niya pirma talaga yon, but because his name is being used, it's his office that's being used to funnel the money, that they can still be liable?
Very good. For purposes of discussion, when you say negligence, there's an element na you did not intentionally do it. And of course, graft and corruption in general has to require an intent. No? It's something you cannot do by default. But negligence can also be, especially gross negligence, can also be punishable. You look at when you're driving a motor vehicle not carefully, reckless imprudence is a form of gross negligence. In these scenarios, criminal charges can lie, which means that if you don't exercise the due care that's required of you, then it's also possible that criminal charges,
criminal negligence in a way,
can happen. So in the plunder case, of course, it's happening, it's shaping, it's developing. We'll have to look at the specific acts and the legal niceties, the technicalities of it. But in principle, plunder would require intent. Just being negligent does not mean that you're excused from any form of criminal liability. But as to how these two things will develop will depend actually on each case that will be pending and continuing.
Asa, can you take us through? No? We've been watching this. All the viewers, Filipino people, the whole country has been watching this, and they've seen the process. At first, they were seeing a lot of course, Justice Secretary De Lima. She was involved. It was in the DOJ. NBI was involved, and then after that,
and even before cases were filed, we actually already heard kung sino yung mga senators involved, just because there was an investigation.
There's investigations going on and all that. And eventually went to the ombudsman and
even the Senate conducted their own fact-finding.
Yeah. So maybe you can, I guess, for the information of the viewers, can you just run us through the structure? No? How something like this happens, and is it the NBI doing it? Is it DOJ? Where do you file directly to the ombudsman and all that? And maybe you can clarify that.
So just we don't confuse the public as much as they're confused already. We can think of it as a value chain. No? An act happens, a criminal act happens. No? In general, it's the police or somebody who responds to an act or a crime. But in certain cases, let's say we talk about plunder. So this act is usually difficult to find because it's nakatago.
Unless you suddenly have a whistleblower, di ba? Kaya
These
nalaman
are
mo na.
intelligent people. These are people who have lawyers, who have accountants, who do all of that. But given that this crime is discovered, but just saying it's a crime, you see it's a crime, especially for what we call white-collar crimes, financial crimes. It's not as easy as saying a rape or a murder or a pickpocket that you can immediately say, hey, pickpocket yan. So from this act, it has to be processed, it has to be investigated. And that is where law enforcement agencies, our NBI or PNP comes in. Since this is a complex litigation, complex case, we would have the NBI, which is specially trained for white-collar crimes, to do the initial investigation. At that point, there would be certain sources of information, including witnesses. When you're asked to testify, you would issue affidavits. So at that point, there would be some information that's available. From that standard, the NBI will complete that into what we call a case investigation and case build-up. And from that, it's given to the prosecutors of the DOJ to do what we call a probable cause determination. That's what we hear about. For graft cases, this is the general situation. For graft cases, it should be the ombudsman who will determine the probable cause. But you have to remember, the ombudsman has a special jurisdiction for graft and corruption cases, only if it is salary grade 27 and above. If you're non-government, salary grade 27 determines the rank or position of the official. Okay. So the ombudsman, Sandigan Bayan, is focused for the higher rank public officials.
Anong type pong salary grade 27?
You would
Is
have
that like
directors.
Okay.
You would have assistant regional directors, assistant directors in certain places, moving all the way up to SG 31. So since all of these accused are more than SG 27, ombudsman will come in. And because NBI is under the DOJ, and because ombudsman does not have a separate quote-unquote NBI, and ombudsman does not also have offices nationwide, but the DOJ has offices nationwide. So we entered into a memorandum of agreement so we can work together to have the mandates, respecting each other's mandates, but at least talking about the same case. No? So from the NBI given to the prosecution of the DOJ, in certain cases like graft, it goes straight to the ombudsman to determine probable cause. Probable cause is the initial stage when you become quote-unquote accused once this case is filed in court. Usually, it's usually filed at the regional trial courts, yung tinatawag na RTC. But again, for ombudsman, our special aversion or special fight against graft and corruption, ombudsman goes to a special court called the
Sandigan Bayan, yes.
So that's the only difference. But in terms of the procedure, the terms of concepts, the presumption of innocence, the checks and balance, it's the same idea from when the crime is committed all the way that it's filed in court, whether Sandigan Bayan or the regional.
But there can
court.
be cases of graft and corruption that doesn't have to go through NBI, Department of Justice.
Yes.
It go directly to ombudsman. All right.
It's possible, but as I said, in certain cases where financial crimes are involved, or it's systemic corruption and it's a huge or grand scale, then it requires a lot more processing at the beginning.
All right. Asek, we need to ask questions from our televiewers. Let's start with Edna, who asks, what acts are considered as plunder? Should there be a specific amount or a high amount of money involved for something to be considered as plunder? I think based on the law, there are a number of
But I think there's
acts,
only one threshold amount. That's what Asek mentioned earlier, which is
50
50 million
pesos.
pesos.
Yes.
Right. And I think there are several ways of doing it. I think there are like 7 or 6. Can you
It's basically what you
rattle them down?
mentioned, Rod. It's misappropriation, the conversion of funds, the misuse of funds that we also mentioned. A lot of this is, again, I would emphasize, not different from the graft and corruption cases that we experience. The thing with the plunder law is, of course, aside from the threshold, you can combine one or two or all of these quote-unquote cited acts that are enumerated in the plunder law. So that is a basic
Main
difference.
difference.
It in a way it expands it because it can be any combination of the series of acts that are mentioned there.
And I guess because the main thing is that plunder is a crime punishable by reclusion perpetua and death, and therefore non-bailable.
Correct.
Yeah,
Which
so-
we will, I think, have to
We'll
discuss also.
later.
We'll discuss
Yeah.
later. All right.
We have another question from Beth. Since the plunder law states that all persons involved will be charged, does this mean that the whistleblowers, Ben Hurluy, will also be charged with plunder? Yeah,
That's
tama naman,
also
because
a very
you're
good question.
Non-government.
In the Philippine legal framework, there are two ways to become witnesses. One is you become witnesses after you have been charged in court.
State witness.
You can become a state witness. The other form, which is through the witness protection program of the Department of Justice, is when you raise your hand and say, I want to report a crime, and you qualify under certain conditions in the witness protection program law, then in that case, you can already be the quote-unquote witness for the state in the beginning, of which you will no longer be, you will actually be witness for the state to complain against certain accused or certain criminals. So basically, in this case, you can be charged altogether in conspiracy, and provided you meet certain elements, one of which is your voluntary admission, your voluntary cooperation with the state, and of course other conditions, you're not being guilty, you can be discharged to become the state witness. That this is the
Any
this is
difference
one
naman
possible.
Yeah,
sorry.
that's why I was gonna ask Asek C, because last week we had a guest from the Ombudsman, Attorney Lopez, who said, for instance, in the case of Ruby Tuason, she was not discharged as a state witness, but she was given immunity by the Ombudsman. And right now we'll have to take a short break, but perhaps this is a question that Asek C can help us address para maintindihan ng mga
We'll try
tao
to
yung
request that we
difference.
have 2 hours with you.
Yes. We'll hold him hostage.
We'll hold you up.
Legal Help Desk will return, so stay tuned. You're still tuned in to Legal Help Desk on the Solar News Channel with our guest, Assistant Secretary Hieronimo C. of the Department of Justice.
Yeah. Okay, so
We'll pick up from that question.
Yeah, we pick up from that question.
Ano yung difference ng being discharged as a state witness and being given immunity by the Ombudsman?
Let me start with answering that question by saying this. No, in cases of grand corruption or systemic corruption, the nature of it is not easy to detect. It's difficult to investigate grand corruption simply because it's a band of people, it's a group of people that comes together with the purpose of hiding, concealing. It's not like a crime of passion, you know, when you have blood spattered.
Actually, I like your analogy kanina. Sabi niya, hindi yan parang rape or murder na may iwan kang victim or may makikita kang trace ng crime, but and someone will complain pag may victim, but here, yung biktima mo is the taxpayers na walang alam na nanakawan pala tayo, right?
So from that perspective alone, this develops through probably 100 years of criminal law enforcement theory, that from this group of 5 or 10 or even as small as 2 or 3, the person who sings, the one who confesses, the one who feels compelled, whether by conscience or the fear of detection or some other impulse for you to come forward, that is not the best case to move forward with the graft and corruption case, simply because of the availability of evidence. You know, there is a deliberate proof to hide evidence, to destroy evidence, to shred documents, to spirit away money, to use dummies. That is the whole nature of grand corruption. But if you have one person saying, I'm going to spill the beans, I can't take this anymore, my God, my conscience, or I fear that I might be silenced or killed, then that person comes about, then that person's testimony becomes one of the main drivers of
But
evidence.
someone who volunteers information, even if he or she was not charged with the crime, is that a whistleblower? Kunwari Ben Hurluy, he was not charged with anything, right? But he suddenly volunteered information.
Which means that fundamentally, there's two differences. A witness protection program, or say if you're witness protection, is because you are a witness to a crime. Whether or not you are part of the crime is immaterial. So you become a protected witness because of your threat to life. If you're a whistleblower, necessarily you would be, quote-unquote, you have privy of that...
you're part of the crime.
Part of the crime. You may or may not have committed it, but you are part of that organization or part of the quote-unquote system, because you did not see it passively while you're being a cigarette vendor or being a TV host. You see a crime, you become a witness. But a whistleblower means you had intimate knowledge, you had intricate knowledge of how it works. So you knew about it. If you did not say anything for a number of years, you may not have benefited, you may not have taken the money, you could have just been the driver, but you were not part of the payola system, then you could qualify under whistleblowers.
So those under the witness protection program are not necessarily whistleblowers.
Correct.
Those are
that
two
is a
different
fundamental difference, because you can be a witness to a crime with or without participation. As long as you're a witness to a crime, you will be protected by the witness protection law.
We discussed last week the whistleblowers law, that they're also provided with certain protection.
Benefits
Correct.
like financial rewards.
So
for
at the
success.
present regime, without the whistleblowers law, if you're a whistleblower, you can apply to be a witness and with protected witness. So that is a general picture, because we're using the terms interchangeably, but we don't have a clear idea difference between a witness protection and whistleblower. So in a way, you can say a witness blower is a form of witness protection in that sense. No? So in the case where you are part of a criminal syndicate conspiracy, then you blow the whistle, literally say, tapos na, tama na. Then you are now officially what we call the whistleblower.
Yeah, and that's why Ben Hurluy can be called a whistleblower, because he was working for one of the accused, which is Nepomuceno.
Now moving towards the second phase is this: we should also clarify a state witness versus immunity. Okay, if you're a state witness, all of these witnesses theoretically are witnesses for the state. It's people of the Philippines versus Rod Nepomuceno. You know?
Let's hope not.
So all of these people who testify are witnesses for the state, for the republic. But in law, we called it a state witness simply because from a witness in general, you qualify the state witness because initially you were an accused. Then you're transferred. You're now testifying against the accused. You moved.
So these are the mga accused na naging witness.
Correct. Then you become a court state witness after being discharged by the court.
Yeah.
So
So
that's
we have to differentiate that, no?
Yeah.
correct.
Yeah.
So you become a witness for the court.
For the state,
Then if you become a state witness, right now, because you're testifying, you're already on the part of the state, then you're immune from prosecution and conviction penalty because
Yeah.
you're no longer part of the accused. You've already been part of the state. Now,
But
if
if
you are
you're-
initially, you already enjoy immunity, which means in the first place, you have not been charged by the crime. You no longer be part of the accused because you've already been a witness for the state in the beginning.
Okay, let's go naman to the issue of bail. No? Marami nang nalilito sa bail na yan. Kasi everyone's saying, well, plunder is a non-bailable offense. And yet, those who are accused and those who have been charged, they're applying for bail. So
Yeah.
people are asking,
Who
why
are,
are they
I
applying?
think
Yeah.
we already have Senator Revilla who
Yeah.
applied for bail.
Yes.
And Senator Estrada as well. Did he already? I think Senator who already filed for bail.
I know for sure Senator Revilla has applied for bail. So I guess people are
Wondering why
without really going through the merits of their petition. But
Is that possible
is it
that an
possible?
accused for plunder will file for bail?
Yeah.
Yes, an accused for bail or for any crime in that matter has the right to bail.
Even if the law says it's a non-bailable offense.
Correct.
Okay.
Which means when I say right to bail, we have to clarify again, and I'm sorry if this has to be in a bit technical. No, when you say right to bail, you have the right to bail, meaning you should be let out by the court, provided you can file bail. As long as you have, let's say, cash bail of say 10,000 pesos, as long as you give that to the court cannot say no, I will not accept it. It should not. You cannot do bail. I will not grant you bail. That right to bail is available in most crimes. When you say right to bail, I have the right to bail. So that's applicable in 90% of
So
the crimes.
that's a right. So-
That's a right. It's
Yeah.
your right. The
Yeah,
court
yeah,
cannot
you're-
say
yeah.
no.
Yeah.
The prosecutor cannot object. Nobody can say
Yeah.
you cannot do it. But in certain cases, when it's non-bailable, you don't have the right to bail. It's not a right to bail. But you have the right to apply for bail.
And then it becomes discretionary.
Correct. Because nobody can deny the fact that even if it's non-bailable, the accused will still file an application for bail. That's your right to file.
when you-
And then I have a
sorry.
question in relation to that. Kasi we have senators who already had warrants of arrest, but instead of being arrested in their homes or at work, they voluntarily surrendered. Will this be something that will be taken into account when they apply for bail? Is that points for them?
Okay. On that right, you have the right to apply for bail. Then the court will look at the bail charge, and in the event where evidence of guilt is strong, there's another condition that comes. If it's strong, the application to bail will be denied. If the evidence is not strong, then even if it's a non-bailable offense, of which you have no right to bail, but you have the right to apply for bail, and if the evidence is not strong, even if it's not bailable, you can be granted bail.
So hindi issue yung if you voluntarily surrendered or
so
not.
it's just because you're charged for a crime that's non-bailable. If the evidence feeling ng court is not that strong, you can be granted bail.
Because the overriding idea is our presumption of innocence. We feel very strongly on the presumption of innocence. Therefore, what are accused, especially high-profile accused, detention is not fun. Even if you're in the house, even if you're anywhere, detention of any form is not good. Especially when our detention and correctional facilities are under-resourced, it's not fun, to say the least, to be detained. But going to the question quickly, Karen, on this surrender. Surrender later on can be mitigating circumstance.
Meaning, for the benefit of our viewers,
Mitigating, it will lessen at least your penalty when you're convicted. In recognition that you did not spend resources for the state, you did not make it difficult, you did not make a mockery of the warrant, that you do it.
So instead of reclusion perpetua, baka less than 40 years, gano'n.
It's a
little lower.
It depends on.
But when someone applies for bail in a non-bailable charge, if someone is charged for a crime that's non-bailable, kanino yung burden of proof? Is it more for the one who's applying for bail, or is it the prosecution who has the burden of proof of proving that
That's
it's
a very good question, Rod. In fact, the prosecution will initially have to come up with the quote-unquote the evidentiary standard to show that evidence of guilt is strong. It becomes the prosecutor to establish that, which will destroy quote-unquote that
Presumption of innocence.
on
Which
paper.
is, okay.
On paper.
What about health and age? Because we all know that the other senator who will be charged is Senator Juan Ponce Enrile, but obviously he's already in his 90s. So a lot of people are wondering, will he still be, one, arrested, and second, will he be automatically entitled to bail? Maybe you can clarify this part.
This is I would say a case of first impression, because in the history of the Philippines in criminal law, we have not encountered these situations. In fact, the secretary was saying, and of course we fully support what she was saying, that this is a turning point also, because while we have in the history of the world heads of state who have gone through similar proceedings, for this kind of cases, again, this is a case of landmarks, no, first of history. And if you see in the history of Plunder being charged against a 90-year-old of legislator, there is nothing in our rules of procedure statute books that clearly says, if you're X age, you're Y age. But on reasons of practicality, given that the person is 90 years old, even the president has already expressed his views on this, then we need to apply the law in this particular instance to see how does this work in terms of upholding justice at all times and looking at particular cases in this situation, and try to balance that. Of course, a lot of people say justice is blind. It's whether it's 90 years old or 18 years old, you do the same treatment. That's also one school of thought. The other school of thought is law is blind, but in reality, you cannot treat a 50-year-old guy and a 90-year-old man in the same way. In the same way. Yeah. So this is something that
you're trying to balance.
More of practical and I guess humane.
It's like the surrender of let's say any person. If you're a fugitive, a high-profile fugitive, there's no point of trying to escape it, because you're a public figure. There's no way. And since you're a public official upholding your mandate, then the act of surrender is actually something that's good. That's something that's done. You don't taxpayers' money to do a wild goose chase, and then
hanapin ka pa, and
especially if you're a public official. So in that sense, it's a good sign for the justice system, for law enforcement to see fugitives of any kind, of any nature, whether you're a robbery, kidnapper, terrorist, to come out, especially if warrants of arrest have already been issued, which means probable cause standard has been met.
Asek, I need to ask this question, because a lot of people are asking about the time aspect. As we have this old adage that says justice delayed, justice denied, and they're curious. No? Now that everything's moving, they're seeing it moving. How long will it take before the actual hearing, and how are we really seeing a protracted procedure here to
public expectations? What can the public expect? How long before the hearing starts for all the three senators? And from that time, how long will it take to get a judgment?
I think that's a very good question. But again, I would like to zoom out, because our topic is more on the general criminal justice approach. No? And not only in cases, but it's simply as applying for licenses or permits. At least now our LTO licenses are within the hour. Our NBI clearance is within the day. Our passport hopefully is.
I was going to say the same thing.
These things are faster.
Yeah,
but we need to quicken the pace. And if all the little things will take time to make an overhaul reform, cases, the movement of cases, which is like processing any other document, but more complicated because there are rights and liberties involved, will take longer. In general, right now, in the trial stage in our lower courts, the average trial period ranges from about 3 to 5 years for a lower court, let's say MTC, RTC, to render a decision. So we do not want to draw a very strict parallelism, because these cases are individually treated. But what we can say and advocate for is that this is not only happening in the criminal justice system. It's happening in getting from Manila to Quezon City on a day-to-day basis. What should take 15 minutes takes an hour. On bad days with rains and everything takes 2 hours. The question is, why aren't we solving these things like as easy as traffic? Wala namang makukulong, wala namang kinakasuhan. Why is it so long for our airports to be better? It's a whole governance issue that time as an element of cost, time as an element of opportunity, time as a basic human need and a human asset and liability is not factored in. It's a systemic, I don't want to say a national culture, but we need to wisen up and think why time and delay seems to be built in anything and everywhere that we face.
But in general, at least, it seems like our justice system is trying to be more efficient. Yes.
There's a lot of reform programs that we've implemented, and hopefully this will continue to see the light of day. Will continue to improve bit by bit. And judicial affidavit rules, the case build-up, case investigation teams, and hopefully the under-resourcing, we can also solve that, and probably some legislative support. It's something that we see every day. You know, A shot B, a driver who actually hit someone. So it's a long-drawn strategic thing, but we should just keep at it.
Okay, thank you. Very informative
Thank you,
and very helpful. We'd like to thank our guest, Assistant Secretary Hieronymus C., for being with us tonight and for explaining to us the plunder law and, of course, the bail and everything relevant to the ongoing cases then.
Marami pa akong tanong, pero let's have dinner lang.
Thank you.
We'll keep him hostage.
We'll keep him hostage, yeah.
Thank you. Legal Help Desk will return after this short break. Welcome back to Legal Help Desk on the Solar News Channel.
Yeah, that was an exciting
today,
discussion.
Very timely topic because a lot of people have always been confused na una-una, bakit ba may mga senators na charged? Bakit sino ba tong si Janet Nepomuceno who's just
but the charge is a plunder.
Oh, exactly. And what is plunder in the first place? So it is very helpful first to distinguish because, again, even if you're not as high profile as a senator or a congressman, you can be charged with graft and corruption. Even if you're just a clerk working for a government agency, pwedeng graft and corruption if, for instance, you misappropriate funds or you use government assets for other purposes, unintended purposes, or kunwari, you're also dealing with fixers, that can be graft and corruption. But plunder is really a series of acts that's covered by the law wherein the offense or the series of acts or a combination of acts will amount to a mass wherein you amass ill-gotten wealth, sorry, nakakabulo siya, amounting to 50 million pesos.
Yan. Basta, in a way, if yun nga, because plunder, by definition, can involve malversation, misuse, conversion, misappropriation. So it doesn't necessarily mean, as explained ni ASEC C, it not necessarily mean that stealing that you got it and you benefited from it. It's also a situation where you prejudice the government. Not necessarily that you got it, but nalugi, in other words, on government and resources of the government that was supposed to be used for a particular purpose was used for another purpose. So in that scenario, that can also be plunder. Now, plunder under the law is a non-bailable offense. It's actually punishable by life or life sentence,
reclusion
perpetua to death, which makes it non-bailable. However, we want to clarify a lot of you are asking, why is it that the senators are still applying for bail, considering that it's a non-bailable offense? Well, they are applying for bail because they're saying that the evidence is not strong. Now, if the judge, for example, decides or feels that the evidence that he's presenting, the prosecution is presenting, is not that strong, pwede pa rin i-grant yung bail, even if it's a non-bailable offense.
And again, if you're convicted of plunder, one of the penalties is actually disqualification from holding public office. And in order to be, for those asking na, we have one ex-president who was already convicted of plunder before, but we see him free right now, no longer in prison and actually in public office. One, plunder can be subject to pardon. and that would remove the prison sentence, or will just charge you from serving the remaining sentence. But I guess the questionable part would be, does it automatically restore yung right mo to run for public office? And that would depend, of course, that would be left to the discretion.
Anyone questions it.
If someone questions it, then it should be settled by the court. There has to be a court ruling on it. And again, kaya naging relevant dito yung bail is because it is a non-bailable offense. But with respect to qualifying for bail, magkaiba yung surrendering, voluntarily surrendering is not a factor in order to be entitled to bail. Our law is very clear that it's non-bailable, meaning in order for you to qualify for bail, it should be discretionary upon the judge based on the evidence, whether it's strong, whether the proof against the people accused are strong.
Yeah, okay, so whether you're in government or you're in the private sector, the important rule to remember, thou shalt not steal. Okay?
No.
Thou shalt not misappropriate.
Don't commit plunder.
Don't commit plunder, whether in the private or public sector, di ba? All right. Okay, so that's our episode for Plunder. Now, over the week, we received some questions from our viewers on topics we have previously discussed, and we'll answer them to serve as a recap. Let's start with RJ. And his question is, we haven't paid the taxes on our house for 21 years now. Can the city government impose penalties on us or repossess our house and sell it?
Okay.
Of course, yeah, well.
Yeah, actually, hindi naman repossess because the ownership lies in the owner. So your failure to pay real estate taxes can lead to a situation wherein the government, the local government can, the BIR, or the local government can actually make an assessment first, and then if yung assessment nyo it becomes unpaid taxes because they're able to prove, you're not able to disprove na hindi mo binayaran yung taxes talaga that should have been lawfully paid, it can lead to a situation where they will have a lien on your property, meaning para siyang
para may mortgage.
Parang sa mga nasanla, nagkakaroon ng attachment dun sa property. So, yung local government ninyo or the BIR can sell the property in order to apply that for the payment of the taxes. So, yun yung danger dito.
So effectively, parang na-repossess na rin. You know, so it's kind of possible. In effect, government will take your house, sell it in an auction, and get the proceeds, and they'll satisfy ano man yung utang mo. But to answer your question, of course, you'll be subject to penalties if all these years you haven't paid. No? I guess the question is more of parang kung nag-lapse na a particular period.
Yeah, there's also a prescriptive period.
Prescriptive
so I
period,
guess you have to check, but the prescriptive period is very long. So kung several years na yan, baka yung last few years na recently na hindi pa kayo nagbabayad ng taxes. Your local, you can be assessed for non-payment of taxes, and then your property can eventually be sold for the payment of the taxes.
Yeah.
Okay, our next recap question is from Emily. Last August 2012, I had an operation to remove my gallbladder. The next year, I had another operation to remove my reproductive organ. As a GSIS member, I applied for benefits out of the operation but was denied. GSIS claimed that the operations done were not work-related. What are the covered health benefits from GSIS? And does it need to be work-related for it to be covered by them?
From what we know in the GSIS, dapat anything that's health-related is covered. Now, your question is a little bit vague because we're not sure, insofar as the removal of your reproductive organ, we don't know if that was a reason of health or you just wanted it removed. Because there's some people like that, no? They just want to remove, let's say, their ovary or their fallopian tube or whatever. And that is usually not covered. So I think it's supposed to be in relation to a particular illness.
And I'd like to clarify din kasi yung concept dati na kailangan work-related is more under the Workmen's Compensation Act. Pero sa GSIS health coverage, hindi naman necessarily na kailangan lahat ng procedure or yung kung may accident or injury, it should be related to work in order to be covered. But I advise na, because it also depends on your premium payments, yung terms and conditions, so ask for a copy of your specific terms and conditions based on yung mga nagawa mo ng premium payments and your contributions to GSIS to see kung ano ba yung mga health conditions and medical procedures that are covered. Kasi baka yun yung reason, wala talaga siya dun sa list ng mga covered health conditions and medical procedures.
Correct. Yeah. So, all right. Our last recap question is from Kiko. I was hired in Dubai but stationed here in the Philippines. Which labor code am I bound by? How about tax payments? Ayan. Okay. Well, so first the labor part.
Well, pag labor, actually, it applies to employers in the Philippines.
Yes,
Kaya nga pagka yung employer mo is abroad, you have to go through the POEA, Philippine Overseas Employment Authority. Kasi yung applicable doon would be the laws of their country in terms of kung ano yung minimum wage, ano yung work conditions. But then if they're basically, so kung expatriate siya seconded here, it's still kung ano yung terms and conditions of work that are applicable there. Or kunwari, considered siyang expat ng Dubai to the Philippines, di ba?
Yeah.
But then, I guess we have to, depende sa labor contract niya eh. Kung you have to check your labor contract.
Check your labor contract and...
Tsaka baka may office...
Yeah, who's your employer?
Is your employer Filipino entity that has an office in Dubai or are they really a Dubai entity?
Number of questions.
Pinadala ka lang dito
number of questions.
work.
One is that, who's paying you? Is it a Philippine entity here? Is it a Philippine branch of the Dubai company that's paying you here and they're paying you the salary, or is it directly remitted to your account from Dubai? So those are a number of things. And of course, what are the terms and conditions of your labor contract? It's only then that you'll find out if you are considered to fall under the labor laws here.
And last question about tax payments. From what I gather from your question, you're a Filipino. So Filipinos have to pay taxes for all of their income from abroad and within the Philippines. May mga exceptions yan if you're an OFW, but generally, lahat ng income mo has to be reported and you have to pay taxes thereon with the BIR of the Philippines.
There's certain rules pa dyan, if you've been staying here, if you're doing business here for more than 183 days, in other words, more than half a year.
Considered kang resident of the Philippines.
Considered resident ka dito, and therefore, you have to pay taxes here, all right? Hope that clarifies it, but it's always best to inquire with a CPA or lawyer, and provide him with all the documents, your contracts and all that, all right? All right, that's all the time that we have for tonight. We'd like to thank our viewers who sent us their questions via social media. If you have any questions, send them to our Facebook and Twitter pages. I'm Atty. Nepomuceno.
And I'm Atty. Karen Jimeno. If you have missed any of our previous episodes, you may watch these at your convenience anytime, anywhere by downloading the Solar News Channel app from Google Play and the Apple App Store. And actually, I'd just like to mention, since with the recent hazing incident na may namatay, there's an anti-hazing law, and actually it's not allowed to have a physical hazing. So for those of you who missed our episode, you can search our episode on the anti-hazing law before. Join us again next Monday as we discuss your legal rights. Good night. The past 2 weeks had some of the most highly anticipated developments in the ongoing cases of the PDAF scandal. 2 of the 3 senators allegedly involved in the pork barrel scandal have been arrested and filed with plunder charges, and both have filed for petitions for bail. While the country waits if the courts will also arrest and file charges against the 3rd senator allegedly involved, the 1st senator to be arrested has already pleaded not guilty to the charges. Debates have started on whether or not the persons involved should have filed for bail, given the gravity of the accusations against them. Under RA 7080 or the Plunder law, plunder is committed when a public officer, either by himself or with the participation of other people, amass ill-gotten wealth through a combination or a series of overt or criminal acts. Under the law, the penalty for proven acts of plunder is life imprisonment and disqualification from holding any position in public office. In the amended Section 2 of RA 7080, based on the death penalty law, anyone who is guilty of the crime of plunder shall be punished by reclusion perpetua to death. The questions that are now on people's minds are, will the Sandigan Bayan
Say informative to look at what exactly plunder would constitute of, because it can be just signing off on a check, it could be receiving 10 million pesos one time, but if it's a series that totals 50 million, that already qualifies as plunder. In fact, in that leading case of Estrada versus Sandigan Bayan, which is easily searchable and
it's public record.
It's public
People
record.
can just search that on the
Correct.
net. Estrada versus Sandigan
The
Bayan.
facts are actually of recent history, recent vintage. This is something that is not of long history. It's a fairly, I would say, jurisprudentially a new case and a landmark case because it was one of the firsts, and the first actually on the plunder law. So from that, I think what's important is it has to be read in relation to the RA 3019, which is the Motherhood Anti-Graft and Corruption Law, and look at that series of actions or omissions. Combinations is the word used in the law that will come up with up to that amount of 50 million pesos. Of course, that is the major difference of plunder. And as I saw earlier in the intro, this plunder is especially pernicious because the penalty is reclusion perpetua to death, which is the most extreme penalty in our revised penal code and in our criminal law statutes.
Okay, it's interesting that you brought up the penalty of reclusion perpetua to death because reclusion perpetua would mean parang lifetime imprisonment. But we have here former President Estrada who was already convicted of plunder before, but now he's actually a public official, a mayor.
So a lot of people are asking that.
Yeah, a lot of people are asking then, akala ko ba na-convict sa plunder? Or they even forget na, nga pala, now that this PDAF case is ongoing, they...
Be that, right?
Correct. In the sense that it's not the quote-unquote what we know as a fixing kind of, naglagay ka ng 50 pesos, 100 pesos to expedite a transaction, that kind would not fall under plunder simply because we always hear complaints of why there is no big fish. Why do we always go against the little 2,000, 5,000, 100,000 cases? And for the really big fishes that we're seeing, which is similar to the PDAF cases now, why are we not seeing these cases out of the woodworks? And perhaps partly because of the times and the good governance platform of the administration, you would see also these things coming out. And all these cases are not happening for the first time. These things have been there since the beginning of several administrations, but it's only now that it's coming out of the woodworks and actually being translated into cases.
As I see, you spoke about big fish, and this brings back memories of one successful plunder case that led to a conviction, which was former President Estrada. So maybe we can define plunder. He was convicted for plunder, right? So I guess to educate the public, when he was convicted, ano yung elements of plunder and what type of offense did our former President Estrada commit in order to be convicted of plunder?
That's a very good question because that's already been translated, thankfully, to jurisprudence. So we are not just discussing academically. There's a leading case called Estrada versus Sandigan Bayan from the former president, and basically, plunder is not any special form of action. It's an illegal series of illegal actions. No, it could be just one act. It could be a pattern, a system. I think that case for the viewers is very.
Grant bail to the two senators accused of plunder. Should they still hold public office while they are awaiting trial? How long before the people see fruition in the pork barrel scandal cases? Good evening. You are watching Legal Help Desk on the Solar News channel. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Karen Jimeno.
And I'm Atty. Nepomuceno. Tonight, in light of the development of the PDAF scandal case, we will discuss the plunder law and how to file a motion for bail, what you need to know about plunder and its penalties, as well as the process and requirements for filing for bail.
Our guest for tonight is Department of Justice Assistant Secretary Jeronimo C. Good evening,
Asek.
and thank you for being
Good
with
evening,
us.
Karen.
Asek.
Good
Good
evening,
evening,
Rod.
Asek. Thank
Good
you
evening
for, thank you
to
for-
everyone.
Yeah, thank you for taking the time.
Especially now, he's been very busy.
I
with
know,
all
I
of
know.
these
It's
cases.
thank you for taking the time because of all that's happening right now, and obviously everyone is reading it in the papers. There are a lot of things going on, and for a lot of people, it's just going like this. No, they kind of don't understand what's going on, what are the processes and all that, and obviously the technical or legal meaning of plunder vis-a-vis.
Yeah. Or
graft,
in the
no?
first
So-
place, maybe we can explain why the PDAF scam is relevant. Meaning, because of the PDAF, what can you file against those people who are involved?
It's a timely topic because not a lot of people understand the relationship between graft and corruption cases and plunder. The way you look at it, graft and corruption cases in general is the range of criminal behavior that is that prohibits public officials and of course including the complicit private persons that are against their violation of their public duties and public trusts. So that is general graft and corruption cases. Plunder, because we've seen that graft and corruption cases are not as effective so far in our history as a country. So plunder was designed as a law especially for big graft and corruption cases that have breached 50 million pesos and above. So the policy of the legislature, which is the plunder law, Republic Act 4020, is actually to come up with heavier penalty for those that are bigger in nature in terms of amount. So you look at the subset of plunder as a part of the bigger set of a graft and corruption case.
Okay. So just para clear to the public, give examples of just graft and corruption cases, for instance.
There's so many cases. One is if you're entrusted with public funds, the use of public funds, you're supposed to use it judiciously. You should not use it for private interest. For example, you would have a construction of a road or an airport or seaports. Whatever fund that is given to you should be used only for that purpose and only used optimized so that the maximum public benefit can be done. This is the concept of taxpayers' money.
And this also applies to the level of even, kunwari, yung mga clerks sa government agency offices.
Yes.
Pagka pumayag sila na mga fixers, for instance,
Correct.
and they're aware, tas they're working with the fixer
Correct.
para mapabilis. That's graft and
Correct.
corruption.
Pero
Okay.
in that case, no, you're not talking about government funds because if it's let's say bribery or let's say parang under the table,
Yeah.
you're talking about the fund of another person.
Correct.
And
So that's
and
another
make
form
money.
of
Yeah,
graft and
so that's
corruption.
graft. So plunder wouldn't